got a new charge, Bubba. Resistant transport. Resistant? I wouldn't resist him. You just resisted transport. Yeah.
What the hell is that?
Now you got a new charge. Yeah.
Come on.
Thank you, Judge.
You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So, Judge.
Listen, you don't need to say a word.
And
What do you want?
Well, I want no PC to be found on the violation of protective order charge because.
Oh, come on. They charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him.
Yes.
That they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone at approximately 3:22 in the morning. Officers were conducting routine patrol at 7-Eleven. And the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and asked for his identification. The suspected charge is theft of a service under penal code.
Oh, come on. They charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him.
Yes.
That there's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so what, so they go up to him, they start talking to him,
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he stated his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
Defendant had outstanding warrants and was placed in custody.
They was.
He was charging his phone.
what do you think? Charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on. Do we need help back there?
No, nothing treats you better.
You all right back there?
Yeah, he's fine. He doesn't care if he wants to go now. He's not getting his way.
Who is it?
I don't even know. The attorney told him he was doing, but I don't know about it.
Okay.
Tyler? Probably. No, it's not. Let me see.
Talk to Pavel, let's see.
Judge, we would, we'll defer to the court. I mean, he didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good. He's not going anywhere, right, on the theft.
I mean,
So-
the way it's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest, I mean, that's.
Do you want to do something with it today anyways?
We weren't. We had something worked out. I didn't like the fact that,
Because it might happen anyways.
I
You know
wanted
what I mean?
time served. I wanted the time served. He offered, he would have to do 24 more days.
I'm okay with that, or I'm okay with whatever you want.
Okay.
It's up to you guys.
Yes, Your Honor. I'll always refer to Pavel with things. After 90 days, depends once time served.
Yes.
Okay, and I'm totally fine with that too.
Okay, thank you. All right,
Thank you.
we'll came up. Thank you.
Later that day.
Alan. Okay, so first we have, is this, that's Rivera and Soto?
With the D.
Oh,
I know
Duarte.
I mispronounced it, so. Pronounce it one more time?
Duto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with 2 cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the
dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it. You know, most times people plead to the theft case and it really hoses them. Because then you're looking at, you know, federal, or not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served. What time are we looking at? No, Roy Duato.
Oh, 18-6.
18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering these agreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Now, Mr. Rivera, you're charged with assault of a family member. You need to understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you'll be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Have you ever been to prison before? It's not a fun place, man. You can never own a gun or ammunition as a result of this plea bargain agreement as well. You picking up a gun is a Class A misdemeanor in and of itself, okay? What time are we looking at on Rivera? 21/7? Okay, so it's 21 days in jail. Credit for the 7 days that you've already done. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your court costs so you won't owe anything, and good luck to you guys. All right.
All right, gentlemen, go ahead and go right through that door for me.
Listen, you don't need to say a word.
Morning, Mr. Bayo. You speak English, right?
Yes.
Okay. Shh. All right, Mr. Bayo, you're charged initially as of, it looks like November 7th, you picked up an assault of a family member. I see now that you've picked up a new case. As of November 30th, you've picked up a violation of a bond condition or protective order. I don't know which it is. All I know is that you picked up a violation case. You're facing now another year in jail and or a $4,000 fine. I haven't done probable cause, so we're going to do that. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. Sir.
Officers were dispatched to a residence in Harris County, Texas, in response to a disturbance. The complainant stated that he was locked out of his residence by his ex-wife's new boyfriend. Complainant went to the residence because his ex-wife had called them and stated that she was going to work. When the complainant asked who would be watching their children, the ex-wife said a friend. Complainant then heard defendant's voice in the background and went over to the apartment. Complaining witness is the same complainant.
You said he heard whose voice?
The complainant heard the defendant's voice in the background. I think that the complainant believed that the defendant would be watching his and his ex-wife's children, and that's why he went over to the apartment. Complainant is the same complainant from a pending AFM, and the apartment address where the defendant was staying is listed on a signed order of protection.
How bad of an assault were we talking in the original case? What happened is
I think it was
Punch,
punching in
slap.
the face with a closed fist.
once, twice, thrice?
2 to 3 times, it looks like, Judge.
Okay.
And I can give some excellent background that I think they're also still working through.
On the assault case, we issued a protective order, I would imagine.
Yes, and I've got a copy of that, Judge, if you need
And
to see.
we ordered him, did we order him not to have contact with this person?
Yes, but that's not the basis of the new charge. And so if we delve into the state's filed information, which is also the basis of the allegation he violated, well, imagine you're hearing both kind of in conjunction, the new charge PC, but also considering the questions of bail with respect to the first charge as well.
Of course.
What's been alleged in the new information is that Mr. Bio went to the residence of the CW, Mr. McWilliams. As of the date when we first appeared in court, the representation was made by both Mr. McWilliams, and then today, the representation was made by the ex-wife of Mr. McWilliams, who is the dating partner of Mr. Bio. So he is dating this gentleman's ex-wife. But she has confirmed to both of us that Mick Williams has moved out of that residence as of the date of the first alleged assault. And Mick Williams has told them that. They have been unable to reach Mick Williams as of recently. But in the RIP call information, Mick Williams confirms, I moved out that day and do not live at the address that's at issue in this VPO case. If you look at the filed information in that VPO case, it's a necessary ingredient of that allegation that Mick Williams lived at that address. It specifically says it in the last line.
You're saying in the protective order?
Yes, Jim. Oh, no, not the protective order. In the violation of protective order case, if you look at the state's filed information in that case, you will see the last line is, to wit, he was at the complainant's residence, but Mr. McWilliams doesn't actually live there. He moved out. Actually, was not on the lease.
He's still not supposed to have contact with this person.
Well, he's not. He didn't have contact with him. What happens is he's at a place that is not McWilliams' address, and then McWilliams, angry that he's there, still wanting to control his ex-wife, comes over there and busts the windows. And so that is
What's the window of
his ex-wife's house where Mr. Biles.
what's the ex-wife's name?
Shannon.
Shannon. Okay, so
And we both spoke to Shannon a few minutes ago.
and Shannon has how many kids with Mr. Bio? Or do they have kids or no? So whose kids are they? McWilliams?
Nick Williams and Shannon's children.
Okay.
I think there's two.
And so what's alleged in the newly filed charging document is that Mr. Bio went to the residence of McWilliams, which there's no PC to believe that. He did not go to the residence of McWilliams. He went to Shannon's residence. McWilliams does not live there, stopped living there, and the state can't meet the information. And so there's no PC on my argument, Judge, is that there's no PC that the state or the officer.
So in our case, in the assault case, the protective order says that he's not supposed to go to this Spring Cypress, the apartment in Spring Cypress, right?
Well, contemplating that that's McWilliams' address.
Is that his address? Yes or no?
That is no longer his address, Judge.
Okay.
When that was filed, I imagine that was the original apartment, but on the
Because a lot of
day,
times they never updated. They just put the original apartment where it happened at, and they always assume that it's this, and, you know, just,
so that's no longer the address. Mr. McWilliams moved out of that address on the day of the incident, and he told me he moved out. I believe that Shannon is the only name on the lease.
for the violation case, where is he alleged to have gone to?
He went to the address that's listed in the original MOA. So he went to the Spring.
Spring Cypress.
Right.
That's right.
Okay,
And
but what he's saying is that this person no longer lives there.
well, that's what McWilliams told the state. And that's what Shannon has told both the state and myself. And that is what our full understanding is. Now, I know that address is listed in the protective order, but what's contemplated by the protective order is don't go to a place where McWilliams lives. And McWilliams is not living at the Spring
But
Cypress.
the problem is that we also have this address there because he could always go back.
Well,
He may not live there. Maybe he lives there partially. Maybe he comes and goes.
what
So
told us was he was
he is
kicked out.
also as a preventative measure so that we don't want you to actually or accidentally bump into this person. And that's why we have this there, is that he did live there at one time. Perhaps he may go back. He left an article of clothing. He left pizza there, or whatever it may be.
Well, what's really happening is he wants to go back and continue harassing his ex-wife. And that is what Shannon has represented, I think, to both of them. I wasn't privy to their phone call, certainly what was represented to me. And
What do you want?
well, I want no PC to be found on the violation of protective order charge because an element of that offense that's been alleged is that Mr. Bio went to the residence of McWilliams. McWilliams does not live there. It's not his residence. So there's no PC to believe that that element is met.
What do you think?
Judge, I don't know, on this matter,
I gotta think, it's expressed in the order. In the order is that address was PC, but the actual location.
I will say, Judge, in the charging instrument, the defendant it does say, he's not allowed to intentionally or knowingly go to a place specifically described in the order. The address in the order, that's where he was staying. But in terms of
The address in the order, who was staying
the defendant was staying at the address in the order.
in this
In the
protective
original
order?
Moab, Spring Cypress.
Okay.
Yes, the defendant was staying there. But I will say in terms of PC, I'm going to defer to the court on this matter.
And may I just read that little blurb of the information that I think is important for the court to hear? May I take a, yes, cheat and steal y'all's computer? Go ahead. So,
Do we still have a problem with him trying to communicate though?
no, he didn't want to have any communication. This gentleman comes over to the place and starts busting the windows.
I will say the complainant came to the place where the defendant was staying. Like he initiated the contact in the situation.
And what's alleged is, and it's the last clause, maybe two clauses, it says a place specifically described in the order, to wit, the residence of a protected individual, namely Mark, and it should say Mick Williams, but it says Mark Williams. So it's in order to meet this charging document, it would have to be that gentleman's residence, and he does not reside there as by his own representation to the state. And so I'd ask that, and I know it's a very unique situation.
How do we go forward though? If I find no PC, how do we go forward? No.
Well, goes back out on bond while we prepare our defense to the initial charge of assault, which I think they've seen quite a bit by way of background about Mr. McWilliams.
How do we know that this isn't going to happen again?
Well,
I will say, I'm not sure where Mr. Byer will be staying if he were to get out on bond, but the witness, Shannon, she is no longer living in her apartment as of tomorrow. So that address will no longer, it won't even belong to any of them as of tomorrow.
Do we do a no contact with both?
We would do no contact with the witness, with
With
Shannon,
Shannon?
but I would ask no contact with Mr. McWilliams.
and
You are now in a relationship with Shannon, right?
that's right, Judge. Just yes. But yes,
So
I've instructed him, just let me answer for him, Judge, but he is in a relationship with Shannon, that's right. And he moved here from Hawaii to be with Shannon, and the ex-husband takes issue with it. And the ex-husband has a very violent history with Shannon. And so long-term, we think there'll be issues with case one even. But I understand that that's not really we're not there yet. I think the question is what to do if he is out. I do think obviously no contact whatsoever in any form, shape at all with Mr. McWilliams is appropriate. And that is what existed. Unfortunately, the state can't even reach McWilliams because he doesn't have a phone number that is even good.
have you run an NCIC check on this McWilliams guy?
We can see his in-county criminal history, but I can run a new check on it.
Do you see? I mean,
I don't want to be
Pretty
incorrect,
expensive.
but I think he's got violent history with Shannon, but maybe Judge, when you get to be my age, it's hard to remember all the details, but I think I recall that, but maybe I'm mistaken. I don't want to represent something inaccurate.
you have inherited a dangerous situation. And Mr. Bio, you need to be very careful. If you are in a relationship with someone and they have another person that's in their life that's like this, you could be the bearer of bad times. So you need to be very careful. You're in a very volatile situation. So you need to be careful going forward because it really could just could go out of control. You may need to get a protective order yourself. It's very possible that you may need to get a protective order. So just be careful. You're in good hands. You ever have any issues, just reach out to Brian. We can always help you out as well. I'll find no PC on the violation of a protective order, but just be careful because there are a lot of vindictive people in this life that will they'll try to make your life a living hell. And you being on bond in this case, they can do that. They can say, hey man, he's doing this to me. He's threatening me. He's doing that. And if an officer doesn't know any better and they come up and they see that have this open assault, they may never take your word. They may never even speak to you. They'll just put you in county. So you gotta be careful. You know, you're in good hands. We'll help you out for as much as we can. Okay. Okay. So I'll find no PC on the,
And I think Judge, what,
on the violation case. And I'm not going to revoke your bond on the original assault case, Mr. Bio, but you got to be careful, man. You know?
and Judge, I think you should also have him give his updated address to pretrial would be appropriate as well.
Okay. And I think that's probably somehow make a notation in everywhere so that we know where Shannon lives. You don't have an address for, McWilliams, so I don't know how we're going to handle
Well, I
that.
think the
but-
protective order does say any address where McWilliams does reside. So whether or not, I mean, I guess that'd be a notice question, but we know not to go anywhere where he lives.
I think the issue is whether this other person's going to now be, yeah.
You do understand all that?
Do you have any questions? Just be careful. Life's too short to live either in a 6x9 box or be 6 feet under because you got other people that have just be careful. All right.
Thank you, Judge.
Good luck. Good luck, Mr. Bio. You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
of course. I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always.
Judge, I hand you DeContal versus State? I just,
You can tell.
yes.
Yeah. Oh, look, it's out of court 8 in Harris County. So why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He
he's
doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's
he-
why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay. At no point is the DA's office called to this point. Okay. That happens after. Fine. For an assault, They can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine, they are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's
It's all-
common for officers to conduct an investigation before they call intake. That's not an abnormal.
Yeah,
thing.
I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I asked at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watching them.
We can watch the video, Judge.
Cue it up. Let's watch.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record it. Mama, look, record him. Now you're under arrest. I'm under arrest. You charged, Bobo. Resistant transport. Resistant? I wasn't resistant. You just resisted transport. Yep.
What the hell is that?
Now you got a new charge. Yep.
Come on.
Thank you,
This
Judge.
officer's not working intake.
Really? That's it?
That's it, Your Honor.
That's the relevant portion that defense is.
Oh, come on.
The officer is investigating legitimate.
I know, but no. All right, I'm with
Do
you.
you see why I'm so upset, Your Honor? Okay. Thank you.